Good morning. My name is Matt Troiani. I'm Vice President of Professional Development and Chief Counsel for the Northern Virginia Association of Realtors. I'd like to welcome you to today's session, which is on fair housing, know your rights and responsibilities. We're going to be getting into it in just a moment, but I wanted to welcome you all to the Northern Virginia Housing Expo. And we're very happy that you've participated and be able to put on this presentation today. I like to do a couple of ground rules before we really get started because this is obviously a virtual environment. So I encourage you all to participate. If you have questions, use the functionality that's available to you. We have a fantastic moderator who will be feeding questions, and there will also be time at the end. I usually teach this class. It takes about 2 hours or so. Yes, you can, Kim reminded me, you can put it in the Q&A, to put the Q&A in the chat box, and we'll follow that along. We'll answer as appropriate, or we'll save it to the end, but I promise we'll make extra time for that. Now, the reason for us kind of putting this together today is to emphasize the importance of fair housing as it relates to the real estate market and the real estate industry. I think that, everybody can justifiably expect more. But what I want to just do very briefly is give an introduction. Why should you be listening to somebody like me? Well, as I mentioned, I'm Chief Counsel and Vice President of Professional Development with the Northern Virginia Association of Realtors. I've been doing this for over 15 years. I've worked in real estate, finance, fair housing. I've done fair housing litigation, consumer protection, and advocacy, and as a part of my legal practice. NVAR, the Northern Virginia Association of Realtors, who I represent, is the voice of real estate in Northern Virginia, and we're always seeking to elevate realtor success in the service of consumers, businesses throughout the region. We're very proud of our professionalism efforts. Realtors adhere to a strict code of ethics and employ professional standards through education, certifications, always being up on best practices. And so we see our role fundamentally as an educational one in order to make sure that real estate professionals are out in the market and are protecting the consumer and doing the right thing. Now, that's about as much content as I'm going to put on a slide this morning. And there's a reason for that. The slides are really designed to kind of give us some guideposts, but mostly this is going to be a conversation. This is a very much a human enterprise. I don't have a whole lot of fancy graphs or anything like that. I want you all to kind of make sure that you're getting the content, because really what this is all about is people acting as humans and relating to one another and treating people the way that they would expect to be treated. So I'd start very, very high level, big picture, asking the big questions, and then we're going to hone down and get into more of the details. So you probably, hopefully most of you have heard these questions. Usually it would start with who, what, where, when, why, and how. Well, I start with the why, and there's a reason for that, because there should be a discussion about your reasons for doing something, because that's going to be your guidepost. That's going to be your North Star. You're going to try to remember that, okay, what is it that we are trying to achieve here? And then we're going to get into who it affects, where it applies, and things like that. So as we go through, we start with, why is fair housing important? Well, this is the ethics professor in me. It is a matter of ethics. Everybody should be aware of fair housing. And as a former ethics professor and somebody who really enjoys talking about these kinds of things, I like to approach it from a variety of different angles. Some people are going to do things just because, hey, it's virtuous, it's the right thing to do. Some people will do it because they want to stay out of trouble. It's the law. That's what the law says. I must do it. And some people need a positive incentive that, okay, what is in it for me? Well, observing fair housing laws is good for business. Now, most people are really actually probably a combination of the three of those things, right? It's kind of all of the above. Most people will see things as, well, it's the right thing to do. It also is going to keep me out of trouble, and it is good for me. But I really want to hone down on that good for business aspect, especially for those who are real estate practitioners here. In Northern Virginia and the DC metro region are among the most diverse places in the entire country. And over 40% of the households in Northern Virginia speak a language other than English at home. If you are going to be successful in this marketplace, you need to be able to be comfortable in talking to people and bridging those cultural divides and serving people regardless of race, color, religion, sex, national origin, familial status, disability, all the categories that we're going to get into. This is going to expand the scope of the clients that you can serve, the people who you work with, and ultimately going to lead to greater success. That's what we believe. So who is this presentation for? This is a little bit different for me. I'm used to presenting to real estate professionals and having a little bit more of a narrow audience, but I'm going to continually try to approach it from multiple perspectives, because I know that the audience here at the Expo is multiple as well. So we're going to be talking about home buyers and sellers, landlords and tenants, realtors and other real estate professionals, lenders, property managers, basically anybody who has any interest, connection, or potential future interest in renting, buying, selling a property, living somewhere, should be aware of the fair housing laws, how they protect them, and how you go about trying to make sure that you're protecting others. Okay. So what are we going to cover today? We're going to go briefly over the history of fair housing laws. Not going to go into a super deep dive. I love history, but we only have an hour today. We're going to get into the federal, state, and local protected classes. We're going to get into prohibited practices. And then we're going to talk about enforcement and remedies and best practices. So, jumping right into it. When is fair housing relevant? Yesterday, today, tomorrow, and always. Most people think of the fair housing laws as being something a little bit more modern, that the Fair Housing Act was passed in 1968. And we're going to get to that. But really, the first major civil rights legislation was passed in 1866, immediately following the Civil War. It was the first federal law to define citizenship and affirm that all citizens are protected by the law. Now, obviously, there was a lot of work that still remained to be done. This was predominantly designed in order to provide protection against people who formerly were enslaved, and ensuring the 14th Amendment was also passed in order to ensure that they were received equal protection under the law. 13th Amendment was passed in order to abolish slavery. There still was a long way to go in addressing other protected classes that we're going to get into. And of course, this was also predominantly only for men. Women, for instance, did not have the right to vote for another almost a little over 50 years. But it was a positive first step. And the reason why I provide this context is that this is something that has been happening for a long time and will continue to evolve. This is very much, it's not just something that we learn about the past. In the 1870s, enforcement was effectively abandoned after the end of Reconstruction in the South. This, gave rise to decades of policies that not only permitted, but almost encouraged by both federal and state governments. Doctrines like separate but equal. There's a famous Supreme Court case called Plessy versus Ferguson, which basically set into place until Brown v. Board of Education, the doctrine of separate but equal as federal and state law. Jim Crow laws were enforced that effectively, disenfranchised people on the basis of race in the South and other areas of the country. And then the federal government, even in the during the Great Depression, and even after World War II, was heavily involved in policies that essentially denied equal access to government benefits, such as subsidized loans, think like the VA loan program, and Fannie Mae and Freddie Mac underwriting standards. These were actually policies that were set into law. We'll get into what redlining, blockbusting, and things like that were, but these were permitted for a very long time, which eventually necessitated the Fair Housing Act of 1968. It was passed mere days after the assassination of Dr. Martin Luther King Jr. It prohibited discrimination in the sale, rental, or financing of housing based on race, religion, national origin, or sex. It was subsequently amended in 1988 to include disability and familial status. Don't worry, we're going to get into all of these things. The Fair Housing Act, as amended, has had a significant effect. I don't think that there's anybody who would argue that things today are not at least somewhat better in most respects than the situation was in 1968. But we still have a lot of work to do. Just a very minor example, and we'll share the slides and everything like that, but would encourage everybody to go and review the Newsday reporting from 2019 in Long Island, New York. A local testing center sent out people into the marketplace on Long Island. And for the record, Long Island is among the most diverse places in the entire world. Long Island includes Queens and Brooklyn and is an incredibly diverse area. And this is in 2019, this is not 50 years ago. They sent out testers into the marketplace and discovered that almost 40% incident rate of discrimination in how real estate practitioners were steering, directing, guiding, or providing availability of housing. So this was for the real estate industry, this was an eye-opening kind of thing. This isn't, a long time ago in a, and this is in a very diverse area. So the fact that this was still happening, caused the real estate industry, particularly realtor associations with whom I work, to look inward and make sure that, hey, what is going on? Do we need to do renewed focus on this? The National Association of Realtors responded by, trying to heighten additional awareness, partnering with the Department of Housing and Urban Development HUD, in order to create educational and informational awareness campaigns. And believe it or not, how I'm here today is, I think, a small part of all of that is we are dedicated to having this be an important conversation and not just something that we treat in the past or we treat as supplemental to what we do. This is the core of what real estate practitioners do and should be doing, is to be aware of this and to combat it and ensure equal access for housing for all. So what is covered? Basically, any type of residential housing is covered by the fair housing laws. Basically, we're talking apartments, condominiums, shelters, transitional housing, single family homes, dorms, manufactured and mobile homes, assisted living facilities. It is a very, very broad category, and that is by design. Who is covered? Well, basically, everybody is covered, but specifically, the focus is members of protected classes, which we'll get into in just a moment. Who isn't covered? There are some exemptions to the statute, but they're very, very narrow. It's basically, they call it the small landlord exception. An owner who does not possess more than 3 dwelling units, or an owner who has 4 dwelling units in one location, but they live in one of the units, is not subject to fair housing laws. But that doesn't mean that that they're not subject to anything. If they work with a real estate agent or practitioner, a real estate licensee, realtor, they are going to be subject to fair housing laws because the person with whom they're working is subject by virtue of their license. But also, more significantly, even if they don't hire a real estate agent or professional, they are not permitted to make discriminatory ads or statements. That still applies even to small landlords. Now, the reason for the exemption, I think some of it was a bit of a carve out because of the concerns of compliance initially, but by and large, in the last 40 years, most people have become more aware of it, and the compliance with the laws has gotten a lot easier. Some situations that do come up from time to time, say that you have somebody who owns a property and they want to perhaps it's let's think maybe like an elderly person or somebody who, a single person who might be concerned about having somebody else live in a room in their property. And so they are able to say, for instance, not publish, but they're at least able to take into account. For security reasons, do I want to have, somebody who might cause, give me some concern for safety or something like that? We're talking about a really narrow scope, and even then, they're not allowed to place an ad or a statement that says, okay, females only or something like that. But it is something maybe they could keep in mind when they're reviewing applications. Very, very, very narrow exception though. So who and where? We're going to go over the protected classes. These are the federally protected classes. These are ones that apply regardless of location anywhere in the United States. Race, color, national origin, that's meaning that as long as people are here legally, whether a permanent legal resident or as a citizen, they cannot be treated differently based off of perhaps coming from another country. Religion, sex, we're generally talking about gender in that scenario, although there was a very interesting recent Supreme Court decision that actually expanded the notion that federally protected classes based on sex also includes protection regarding sexual orientation and gender identity. We don't have to worry about that quite as much in Virginia, as we're going to see on the next slide, because Virginia actually became the first southern state to explicitly include sexual orientation and gender identity as a protected class. Familial status. This one gets a lot of confusion. Familial status is specifically designed to protect people with dependents or children under the age of 18 from housing discrimination. It's not just any type of family. We're specifically talking about those with dependents and minors in the household. And disability. Disability we will get into a little bit more because that's a very hot topic right now with respect to modifications to property and reasonable accommodations, assistance animals and service animals, things like that. So these are the state protected classes. These are going to protect you anywhere you are in Virginia. Elderliness. Now that can vary by area. For instance, for employment purposes, I believe it's 45 in Fairfax County. But generally speaking in Virginia, what this means is that if this is what permits like 55 and over communities and things like that, they're considered a protected class, and therefore they can put certain restrictions in place that only people in certain communities they can restrict that to 55 and over. Or they can also ensure that there is no discrimination on the basis of a person based off of their age. I just mentioned sexual orientation and gender identity were new protected classes in Virginia. Fortunately, the realtors that we represent and work with are already familiar with this because that has been considered a protected class under the Realtor Code of Ethics for quite some time. Source of funds. This is a really interesting one. This is very newly adopted. It's only been about not even a year, I think. Source of funds, we are talking about receiving governmental benefits or subsidies in order to have access to housing. Some of the ones that you would think of would be housing choice vouchers, Section 8 programs, things like that. But it could also include like veterans benefits or other governmental benefits. Now, there are exemptions to this under Virginia law. It only applies to landlords who have 5 or more rental dwelling units, properties that they rent out in Virginia. It also requires that the applicant who is seeking housing can provide proof of their source of funds within 15 days of application. That's how long the landlord or the property manager has to keep it open at that point. If the source of funds has not been proven or provided, the landlord or the property manager can reject the application on that basis without it being considered discrimination. But this was a significant step forward. It was a long time coming in Virginia. But for a variety of reasons, there are some housing providers who have resisted it, not because they don't believe in people having equal access to housing, but more of a situation where the compliance with the programs can be difficult, forcing landlords to keep properties off of the market for quite some time. But those programs are significantly improving to ensure that people are able to get into the property with support. What was formerly called veteran status last year, it's being clarified in the current legislation that was approved this spring, is defined as a military status, is also considered a protected class in Virginia. Typically in that scenario, what we're talking about is a landlord might be hesitant to lease a property to somebody who is in the military or their spouse because they may be redeployed at a certain time. There are additional hurdles under the Service or Civil Relief Act that a landlord might have to jump through. And so that was the basis for expanding that protected class to ensure they have access to housing. For those of you who might have access to VA benefits, that also might be included in source of funds. If you have VA benefits in order to help you be able to pay rent, for instance. However, the guidance that we are getting from the Attorney General of Virginia is that this does not apply to military or veterans who are using the VA loan program. A seller could still prefer perhaps cash or conventional or some other kind of financing program over VA without it being considered discrimination under the statute. But we're waiting on that guidance right now. And then there are a few more city and county protected classes in the area. Most of them in Northern Virginia include marital status. Many of them used to include sexual orientation or gender identity at the local level until, of course, it became a statewide matter. Okay, so what are we talking about when it comes to prohibited acts? We're talking about refusing to sell or rent a property to somebody on the basis of a protected class or characteristic. That I do not want to sell or rent my property to somebody because of their race, their color, their religion, their national origin, familial status, age, disability, sexual orientation, gender identity. That is the basis for rejecting somebody, to say, I am not going to do business with you because you're different from me in a way that is protected by law. I don't like it. And we do see that does still happen sometimes, but it is becoming less and less. I would say that a lot more of it is less obvious than that. It's more subtle. We'll see issues where you're going to enforce or offer discriminatory terms or conditions. Maybe as a landlord or a property manager, you'd rent out a property to somebody, but you require people of certain backgrounds to pay a higher security deposit or pay more in rent, or you scrutinize their background checks or their credit reports more closely. You require a higher credit score on the basis of somebody's race or something like that. To advertise a discriminatory preference, again, the language is becoming much more subtle. It's not, well, I don't want to rent to these kinds of people. What you see more often is, and it's not even something you would always necessarily think of, but when you're advertising a property, you say it's walking distance to public transportation, to the bus or to the metro or something like that. Well, okay, but not everybody, is that unconsciously or perhaps, subtly trying to suggest that this is not an appropriate place for persons with a physical disability. Advertising a discriminatory preference, saying that, no children, or limiting the occupancy of a place other than based off of the zoning laws, which says how many people can live in a specific location. It has become much more subtle, but it does still happen, or maximum of 2 incomes to qualify or something like that. Now, single persons are not necessarily a protected class, but you do seem to be signaling that you might treat people differently depending on their relationship to one another and how they are applying. Engage in blockbusting or steering or redlining. These are very, very kind of technical terms, but I'm going to give a broad overview. Redlining is just what it meant back before the passing of the Civil Rights Act, or I'm sorry, the Fair Housing Act in 1968. Almost every lender who was receiving governmental loans, whether it's Fannie Mae or Freddie Mac, or FHA or VA, literally had maps where there were areas that were outlined in green where you could, where lenders could actually lend mortgages, lend money to purchase a property in those areas. And then there were areas that were outlined in red where they could not. And I'll give you a few guesses as to who lived in those specific areas. Typically speaking, the green areas were those where predominantly white households resided, and the red-lined areas were typically Black, African American, Latino, Latina, Latinx areas. And so quite literally, you could not get a federally subsidized or guaranteed federal loan in those areas, and it was completely based off of race, color, and national origin. Blockbusting was also an interesting tactic that people would use back in the day, and that shamefully real estate professionals were actively involved in, is that real estate professionals would go into a neighborhood that might conceivably be going through a transition, and they would actually hire persons of color in order to come in and kind of walk around the neighborhood and make it look like they were interested in buying there. And they would create some kind of like panic in some of the perhaps the white households that were living there, and then they would go and sell their properties to real estate agents at a reduced cost and move out of that neighborhood. Then those real estate agents would turn around and flip and sell the property to persons of color, for instance, or something like that, to at a higher sales price. And this deprived wealth out of certain communities and made it much more difficult for people of protected class to actually build wealth, because they essentially were put into areas where the property values were going down and they were paying a higher price. I would say that steering is probably the most common that still is occurring in this category. When we think of steering, we think of an agent making an assumption about a person based off of a protected characteristic and only showing them properties that they think the person would be interested in. Okay, you come from a certain background, say for instance, an Asian American or something like that. Well, I'm going to go and I'm going to only show you properties in areas where there might be other people of Asian descent that live in that area, for instance, making an assumption about what somebody wants. Or if somebody of a certain religion, you're only going to show them properties in an area where there might be, predominant people, whether it be, a Muslim, Jewish, or other religions. You're steering them, not asking the client what they want and what they're looking for. You're making an assumption based off of who they are, and you consciously or subconsciously only show them properties that you think would be a good fit for them, not actually responding to what they want. And of course, harass, threaten, intimidate, coerce, or retaliate. These are all prohibited acts. You would see this mostly in situations where, leasing, where the landlord, a landlord or a property manager treats somebody differently because they have tried to assert their rights under the fair housing laws. You can't treat me this way because of a protected class, and then the landlord tries, or the property manager tries to make their life miserable. I can't evict you, but I'm going to make you want to leave because I'm going to, charge you a late charge because you're 5 minutes late on the rent, or I'm going to enforce the community policies more aggressively towards you. Things like that. That is essentially making somebody really uncomfortable and threatening their quiet enjoyment of the property to which they have a right. And of course, to retaliate if they have actually exercised those rights. Okay, advertising. This is probably the most obvious way to get in trouble because it's in writing usually. It's something where somebody can literally hold something up and say, look, you said this or you did this. It is always a violation. Regardless, there's no exemption for this. Remember, even small landlord exemption does not apply to this. To make, print, or publish any discriminatory ads or make any statements. The bottom line is that you keep everything neutral. You don't use any preferential language. You focus on the property features and not the person. Instead of saying something like perfect for families, you talk about the size of the property. It's got 4 bedrooms and 3.5 bath. It's in a, you can talk generally about the neighborhood without referring to the people who actually live there. And what you're allowing a buyer or a tenant to do is make an informed decision about whether or not it's right for them based on objective criteria. Like I mentioned before, the thing about, walk to public transportation or walk to some kind of amenities. Instead, describe the distance. 5 blocks from the metro, 4 blocks from this grocery store or this community center or something like that. And then let the person make the inference as to, distance is something that they can determine for themselves. It's not making an assumption based off of a person's capability or anything like that. This is not a 100% thing, but it is I consider a best practice under HUD guidelines is real estate practitioners and professionals should use the Fair Housing and Equal Housing Opportunity logos. This is a way to demonstrate to the public that they are dedicated to these principles and to best practices and to comply with the law and treat everybody equally. Okay, so this is an area where we get a lot of questions among our members, is what comes to discrimination on the basis of disability. What rights do persons with a disability or disability-related need have? Now, the standards under the Fair Housing Act are not intended to substitute compliance with the Americans with Disabilities Act. The Americans with Disabilities Act was a focus on ensuring that after 1991, new housing was built with people in mind in order to be more accessible to persons with disabilities. So that was more of a forward-facing law that, hey, if you're building property after 1991, 1992, that you're going to ensure that there are, accessible ramps, elevators, and things like that. Wasn't necessarily requiring buildings to go and retrofit these things, although that is a good thing, but it was mostly focused going forward. In the fair housing context, we're talking about looking more backward. We're saying, okay, there is a property that was perhaps not built, it was built before the Americans with Disabilities Act, or it was exempt and wasn't required to be built this way. But now you have a person with a disability who is looking to live there, and they're asking for a reasonable accommodation. The reasonable accommodation can fit into 2 categories. One is a modification to the physical features of the unit or to the property, and the other is an accommodation regarding policies based off of disability. We'll get to the policies here in a sec. Now, in many instances, the disability may be reasonable or readily apparent. For instance, if a person has a assisted walking device or a wheelchair or something like that, don't make them get up and prove to you that they cannot walk. That is completely inappropriate. That is reasonable or readily apparent. If the person has a visual impairment or a hearing impairment, don't wave your hands in front of their eyes. Don't snap your fingers in the ears. Those are reasonable and readily apparent. In those situations, the best practice, of course, is the landlord, the property manager, seller, real estate agent to take the person, at their word. This is not something that most people would go and try to, to lie about. However, there are many types of disabilities that are not reasonable or readily apparent. Thinking like mental health or internal physiological disabilities, persons with diabetes or seizures or Parkinson's and things like that. It might not always be readily apparent unless the person is in the middle of an episode, or mental health issues obviously are not frequently not observable in limited settings. So in those situations, a landlord, a property manager, a real estate agent can request a verification of disability. This is paperwork that is usually provided by a person that's called a verifier. The verifier is someone with whom the person claiming the disability or the disability-related need has a therapeutic relationship with. This is a very broad category. Think like social workers, psychologists, psychiatrists, primary care physicians. Even in certain contexts, for instance, I believe that there have been persons who have, been injured or have PTSD in the military, even their spouses who care for them, or their significant others who care for them in certain contexts can be considered a verifier. And this person, they're not required to give away like confidential health information or anything like that. All they say is, I have a therapeutic relationship with this person, and they have a disability related need, and the accommodation that we are requesting is related to that disability related need. A disability is defined as a physical or mental impairment which substantially limits, sorry, I saw that's two L's now, one or more major life activities, a record of having such impairment or being regarded as having such impairment. This is a really broad category, and we generally train our real estate agents to, certainly, follow the paperwork, follow the guidance, but ultimately it's not really your place to question or substitute your judgment for that of a medical or health professional. So when we're talking about reasonable accommodations, we're going to address, modifications, physical modifications to the unit, to the property, to the area surrounding it. Typically speaking, it can be done at the tenant's expense. It's not required necessarily the landlord has to pay for it. Think of some of the things that we're talking about here. Installing safety rails in the bathrooms that somebody can get onto the toilet or get in and out of the shower or the bathtub, or maybe changing it from a bathtub to a walk-in shower or something like that. Those are some of the things we're talking about. If somebody is in a wheelchair, for instance, lowering the lights, lowering the door handles, lowering countertops and things like that, those are modifications that can be granted. If you're in an apartment building, maybe installing a ramp or something like that might be appropriate if steps are necessary to navigate to get in and out of the building. Then the landlord may require, although they're not required to, that the tenant restore the property to the original condition at the end of the tenancy. Now, some landlords might actually want to keep the modification. That they can say, okay, well, actually, I'd like to be able to, when this tenant leaves the property, I'd like to be able to advertise this as a accessible unit. And so I'm not going to require them to put things back. I'm going to maintain that improvement. They do have that choice, that option, but they may require the tenant restore the unit to the original condition at the end of the tenancy. The landlord can reasonably require that the tenant use a licensed contractor or designer and things like that in order to actually make these changes. And the landlord may collect a deposit. They're not required to, but they may collect a deposit to ensure that the property is restored to its original condition. It's essentially, but it has to be reasonably related to the restoration of the property. You can't require somebody, if it would cost $3,000 to restore the property back, you can't collect $10,000. It has to be reasonably related to the amounts that we're talking about. The accommodation rule or policy is a little bit trickier. When we're talking about rules and policies, we're talking about a wide variety of things. So let's think of an accommodation regarding the landlord requires that somebody physically deliver a check to a certain office. That's their policy. You have to bring it in. The rent is due on the 1st of the month. You have to bring it in by the 5th day of the month physically to this location. But the person maybe has a mobility impairment or something like that. Well, then the tenant could make a request that the landlord modify their rule or policy to permit electronic delivery or deposit of checks, delivery by mail or something like that, or give somebody else the ability to bring the payment in. One that comes up a lot is in the context of assistance animals. Many landlords or homeowners associations or condominiums or apartment buildings have restrictions. They can say that, oh, no animals or no pets, or maybe a limit on, you can have one pet, but it's, or one animal, but it's limited to dogs or cats, and they have to be under like 40 pounds or something like that. You see these restrictions fairly commonly in our area. But Assistance animals is a really broad category. It actually includes both service animals and other animals such as emotional support animals. Now, service animals are trained and certified to fulfill a very specific thing. Think like, dogs that are designed in order to help somebody with a vision impairment navigate about. There are actually dogs that are trained in order to be able to identify when somebody might be having a seizure or might go into diabetic shock or something like that. They're actually there to alert the person to some underlying health condition before it gets to the point where they might actually be in jeopardy, so that they know they need to take medication or do something like that. So that's a pretty specific category. They are certified and trained for those basic things. Also, a recent one that was announced by Housing and Urban Development was primates. Certain types of monkeys are actually for persons who might have hand-related disabilities. They can't open things. That they have primates who are trained in order to open things so that they can have access to things in their property. Emotional support animals are a different category. Emotional support animals are not certified. We see people try to submit things, they pull it from they get some certificate from some place in like Kansas or something like that, that this is a certified emotional support animal. And as a matter of law, there isn't really any such thing. What we do is we go through the verification of disability analysis there. So for instance, the person with a disability gets the verifier to say this person has a disability related need, and the dog, the cat, the parakeet, the snake or lizard or whatever the case may be helps with that disability related need. And that is the end of the analysis as to whether or not that animal provides emotional support. The most significant thing, though, with assistance animals is they are not pets. No additional deposit or rent can be charged. The landlord may have to modify or waive a pet or animal policy in order to allow it, because you think of this as that it's not a pet, it is something that helps with a disability related need. It would be the same thing as a walker or a wheelchair ramp or something like that. So the question for the landlord or the property manager becomes is the accommodation reasonable? And most of the time it's going to be. Or the HOA or the condominium or the apartment. They were all subject to this. Does that mean that you can bring like a horse into a 2-bedroom condominium or apartment? Probably not. That's probably not a reasonable accommodation. Agriculture, there's a distinction between like agricultural animals and animals that would be typically permitted in a household context. Or maybe the person has more than one emotional support animal. Maybe the landlord has a restriction on you can have only one animal, but the person has 3 guinea pigs or several cats or dogs or something like that. The landlord may have to modify that. Now, does that mean that you can have like 40 animals in one property? Again, probably not. There is a reasonableness standard here. But most of the time when you're talking about most of your kind of common animals you'd have around a household, and it's a reasonable number compared to the space, it's going to be considered a reasonable accommodation. The landlord or the property manager of the HOA condo is going to have to modify their policies in that specific context. So ultimately, where we wrap up here today is that, well, how do we go about doing this? As if I am a consumer, I'm a buyer, I'm a seller, I'm a tenant, I'm looking for somebody to work with. These are the things that you need to look out for. But if you are a real estate practitioner, if you are a landlord, you are a property manager, you are a real estate agent, you are a lender, these are the things that you have to keep in mind when you're providing that information. You have to provide equal professional services. You treat everybody as an individual, and you work with them based off of their individual needs and preferences. You do not make assumptions about them. You do not, try to, make the decision for them. Your job is to provide information with which a consumer can make an informed decision. And if you are the consumer, you need to watch out for people who are making assumptions about what you need. Work with somebody who's actively listening to you and your preferences and what you're looking for. Lead prospects to objective information sources. We think of using the multiple listing service. If you are a real estate practitioner and your clients ask you, well, what are the good, where are the good schools? This is one that comes up sometimes that may not necessarily be intuitive. Well, what you can do as a real estate professional is provide the resources for the client to make their own informed decision. Because what constitutes a good school to somebody can vary. It's not just test scores. It's not just the community. You don't go and say, well, okay, this person is a member of this, race or ethnicity or background or something like that, and then say, well, there's a lot of people like that who go to that, that school. Maybe you should live there. There are resources that are provided by the counties and by the state with which people can look at information about the schools, test scores, programs. Maybe people look for, supplemental activities or things like that. Maybe they're just looking for convenience. They're looking for size. People look for a lot of different things. Don't make assumptions about, what school would be right for them just based off of who they are. People are looking for crime statistics and things like that. Direct them to the resource to do the research themselves without making assumptions based off of what they're looking for. And make sure that that you're keeping up on changes. I mentioned 4 relatively new protected classes in Virginia. These things do evolve over time, as they should. I mean, we went on a journey all the way back to 1866, through today, and it is a constantly evolving thing. I didn't specifically get into Maryland or DC. I'm licensed in those jurisdictions. They have significantly more protected classes than Virginia does. So you need to work with professionals who are aware of what's happening and where they're practicing and understand the distinctions and the differences. And if you are a professional, then you need to make sure that you are keeping up on the changes in the law. This stuff can move pretty quickly, but ignorance of the law is no excuse. When you are a landlord, or you're a property manager, or you're a real estate agent, you need to have standardized qualification processes. These are things that you do every single time. You're not treating anybody differently. And so that could be looking at, like in the context of leasing, that it could be looking at credit scores, looking at background checks and information, but doing it consistently. It could be looking at debt to income ratios and income for qualification and things like that. But you treat everybody the same, regardless of race, religion, color, sex, national origin, marital status, disability, age, familial status, sexual orientation, gender identity, all the protected classes. Maintain confidentiality. When you're sharing certain types of information, you've got, even if they're not necessarily a client, you're not going out and sharing the information about them. One of the really important things that a property manager or a real estate agent can do is, especially in the leasing context, is provide a screening function. The way that we've structured our rental application, for instance, it's the agent who's doing the verifications. They're not even passing along social security numbers and credit reports and things like that, or health and confidential health information to the landlord. They're just saying, look, we've gone through the screening. Here is the objective criteria. We're not talking about the person's ethnicity. We're not talking about their color, their race, their religion, their sex, their sexual orientation, or gender identity. We're just identifying this is the individual and this is the objective criteria on which you should be considering whether or not you want to lease the property to this person. So you've got to handle these things with sensitivity, and sometimes you're almost kind of protecting your client from themselves. And promptly respond to modification or accommodation requests. These do come up, and they do require a little bit more due diligence, but you can't just bury them and ignore them. That would be potential discrimination on the basis of disability. So you've got a sometimes if you are say, for instance, you're representing a landlord who owns a property in a HOA or a condominium, you might be willing to make the exception to the policy, but the HOA or the condominium has the same policy. well, you would have to go to them promptly in order to ask them to issue a waiver as well. And so that might take a little bit of extra time. Or if somebody's requesting a reasonable modification of the property, you could say promptly, can you please provide specifications on what changes are going to be made and information about the licensed person who's going to be doing the changes. Again, it's an extra step, but you just got to be going through the process and do it in a in a prompt manner. Enforcements and remedies. Particularly if you're a real estate practitioner and you see somebody else doing this, or if you are a consumer and you see this happening by a licensed individual, you need to report suspected discrimination immediately. Now, there are a variety of resources that you have that you can report, to which you can report. If you're working with a real estate agent, report it. So if it's somebody else's real estate agent, you can report it to your agent and or the broker. If it's your agent that's doing it, you can go and report it to their broker, their supervisor, to see if they can, remedy the situation and prevent future reoccurrence. You're not required to do this, but it is, something where you might get a prompter resolution to the issue than going through the formal complaint process, but you're not required to. You can also report to the Department of Housing and Urban Development or to their local affiliate. So in our area, that means you can report to the state. The state has a Fair Housing Board. There's the Department of Housing and Community Development, and pretty much all of the cities and counties have an enforcement. It's usually within their housing department, or for instance, in Fairfax County, it's called the Office of Human Rights and Office of Human Rights and Equity Programs, for instance. And then there's a state licensing authority. If the person is licensed, if they are a lender, if they are a settlement agent, if they are a real estate agent, they are licensed in the state, and you can report them, because discrimination is typically going to be a violation of their licensing requirements. If the issue is with a realtor, we have our own code of ethics and enforcement process as well. You can report to the association to which they belong, and we have enforcement processes there as well. We also, at least in the case of my association, offer mediation and ombudsman services as well to try to address these things. So it's still is happening. I think that we have made a lot of progress, but the most important thing is to have continued awareness and discussion on these issues, so that consumers make sure that they understand their rights and what they can reasonably expect of working with others, and that the professionals in the space are aware of the changes as they happen and are aware of best practices. So with that, I am going to stop sharing my screen. But I think that we might have had some questions come in. Otherwise, I'm going to give Kim an opportunity to also say hello to everybody.
Yeah, hi, Matt. We did have one question come in. The attendee says they are living in a low-income apartment and they want to request a small water machine, so I'm assuming a water filter, that can adjust the quality of the water. It is a simple fix at the tip of the tap, but the property manager refuses to fix. Is there something they can do?
So the question is, who does the property manager represent? If you're in a building, it might be worth in your scenario, perhaps talking to an attorney to write a letter. For better or for worse, when people get a letter from somebody with Esquire on the end of their name, some people will respond more quickly. If it's something where cost might be an issue, you could consider looking at the Legal Services of Northern Virginia. They are able to offer free or reduced legal services in these areas to stand up for tenant rights. If you qualify from an income standpoint, and they can represent you. Sometimes threatening to report them also helps. The question is the modification reasonable? And so, that's going to be a case-by-case kind of situation. I don't want to come across as too much of a lawyer here, but the answer is usually it depends. But if it's something where, the installation of this is not going to cause systems to fail, it's not going to be compatible with the piping or anything like that, typically speaking, the landlord is going to have to permit the use. The question from a fair housing standpoint is that what is the basis for this request? Is it on the basis of some kind of protected status? Is there, for instance, a disability involved? Is this associated with a disability-related need? Because in that scenario, you're using significantly more rights under the law. If it's just, well, this would be something that I would like to have, I still think most of the time if it's not going to cause an issue with the unit, it's not something the landlord or the property manager should probably get too worked up over. But you're on significantly stronger ground if it's related to protected status, particularly a disability related need, or if you know that perhaps somebody else in the building of a different race, ethnicity, color, gender, or something like that was given permission for the same thing by the landlord, but the landlord or the property manager is refusing to allow you to do that, and maybe there's a discrepancy there. That was kind of long-winded, but I hope that I covered all the bases there.
You were very thorough. I would just like to add that in certain jurisdictions, there is also like a landlord-tenant relations department or a landlord-tenant relations board that you can speak to, and they may be able to help mediate. So one of those in Alexandria, and I know Arlington has a similar board. So I would check to see if your jurisdiction has something similar that might be able to mediate this for you.
That's a fantastic suggestion. I mean, ultimately at the end of the day, going automatically to litigation is pretty much the only people that helps tends to be the lawyers. The only people that make money in litigation are lawyers. It doesn't mean that you shouldn't stand up for your rights, but sometimes it becomes more of a situation where somebody just needs to be informed as to what they're doing wrong. Sometimes it's ignorance, sometimes it's willful, but understanding that this is what the law requires, and that really at the end of the day, this isn't going to harm you at all, landlord or property manager or whatever. Coming to a mutually satisfactory resolution is an opportunity for learning. It's an opportunity for growth. And you're going to continue to probably live in the property for a little while longer too. It would be better for you to have a more relationship with the person who, the landlord or the property manager. So there's an opportunity there to improve the relationship rather than making it adversarial, but still getting everybody to where they need to be and making sure that people's rights are protected.
All right. Let's see. We had another question. My question is, the burden of supplies and commuting is very high for low-income communities. Is there some information realtor brokers might advise to mitigate this unequal burden?
Well, one thing that we support, I'm not on our government affairs team, but I work very closely with our government affairs team to do a fair amount of advocacy to expand access to public transportation in our area, even though it technically may not be usually it means that there's a tax, on certain kinds of property transactions, but we support that to ensure broader and more equal access to public transportation, because we believe that is a housing related issue, and it's a very important one. And so these projects do take a little bit longer to get through, especially the pandemic the past year I think has slowed quite a bit of development there. I would talk to your local, your county and your cities have resources, some of which you might not even necessarily be aware of. Housing does tend to be priced higher in areas that are accessible to public transportation because that is considered an amenity and that's what the market demands. But people can also look into whether or not they might qualify for partial subsidies or housing choice vouchers or credits in order to help reduce that burden. You know, it certainly is, these things are shared unequally across society, and it's something that we are very mindful of, particularly as it impacts people based off of their background. But I think the longer term answer to that is to encourage more transportation options and to continue to uh, ensure that there are housing options. Like I don't want to speak for the city of Alexandria, Kim, but I do know that you all have a very aggressive affordable dwelling unit and moderately priced dwelling unit program. When new buildings are put in, things like that, they are required part of their their ability to build there is to make sure that a certain percentage of their units are moderately priced, and those are other things that we can do at a policy level in order to ensure that people have affordable access to quality housing.
Yes, we can't mandate it, but we do strongly encourage developers to put in affordable housing in their buildings. And as he said, if you check with your local jurisdictions, their housing departments usually will have a guide to affordable properties. We have an apartment guide that comes out roughly every month with available units. So we are wrapping up. The slides should be available on the Northern Virginia Housing Expo website, along with some frequently asked questions. And the video will be available on YouTube at 2 o'clock, I believe. So if you need any more information, please go to the website and you'll be able to see it. The video will also be up on the Facebook page. There will also be a schedule of other workshops and the virtual exhibit hall, which a lot of the jurisdictions have a booth at, so you can go check out what's going on in your city or county.
Thank you all for your time and your attention. We look forward to your continued participation in the expo. Go visit those the exhibit hall. Those people who are able to make all of this possible, and special thanks to the organizers for this as well, and Kim for you being along for the ride and helping get through it.